Good morning. I'm going to give my decision on the Rule 9 applications. The original Rule 9 application on behalf of P.C. Walker, Miss Short, and the Scottish Police Federation contained a total of 144 questions. I should say in passing that what I am looking for in written applications under Rule 9 are proposed lines of questioning rather than a list of questions. Be that as it may, I'm grateful to the Dean of Faculty and Senior Counsel to the inquiry for significantly reducing the scale of the application. That has made it easier for me to identify and assess the lines of questioning contained in the questions and decide whether any should be permitted. In addition, the Dean identified a number of specific paragraphs in the inquiry statement of Martin Graves, under reference to which he sought to explore differences between the evidence of Miss Caffrey and Mr. Graves. I remind myself that this is an inquiry under the Inquiries Act 2005 and subject to the statutory provisions in relation to the examination of witnesses. In considering whether to permit examination of witnesses by the legal representatives of core participants, I have at the forefront of my mind whether the examination is likely to assist the inquiry. Against that background, I considered whether the proposed lines of questioning would be likely to assist the inquiry. I think that it is important to note the way in which the evidence of both Miss Caffrey and Mr. Graves evolved. In Miss Caffrey's report and in the inquiry statement of Mr. Graves, each was asked to address the primary evidence. In their oral evidence, they addressed a number of hypothetical scenarios based on the primary evidence. In each case, their oral evidence was given with the benefit of additional information produced since the date, respectively, of Miss Caffrey's report and Mr. Graves' inquiry statement. This means that in each case, it will be necessary for me to have regard to their evidence in the light of its evolving nature. Given that evolving nature, I do not think that it would assist the inquiry for the Dean to explore at this stage, under reference to specified paragraphs in the inquiry statement of Mr. Graves, differences between Miss Caffrey's evidence and specific matters in Mr. Graves' inquiry statement. In my view, there is sufficient material as a whole before the inquiry to allow such differences to be explored in submissions in due course. The evidence of Miss Caffrey and Mr. Graves has provided me with a framework against which I can test the evidence which I find proved. My assessment of the primary evidence will, of course, involve assessments of credibility and reliability. That assessment of the primary evidence, and whether I accept the evidence of Miss Caffrey and or Mr. Graves, in whole or in part, will be a matter for me. I anticipate that the submissions of counsel for core participants will be of great assistance to me in these endeavours. As a general proposition, I consider that it would not assist the inquiry to engage at this stage in an exercise of putting to this witness details of what primary witnesses said for further comment by this witness. It seems to me that the inquiry would be better assisted by core participants making submissions based on the primary evidence. I consider that questions in relation to the expertise of Ms. Caffrey, questions of the weight to be accorded to her evidence, and questions of the application of her expertise to the primary facts are all best dealt with in submission. I do not consider that it is necessary, as a matter of fairness to the witness, to explore every respect in which criticism might be made of her evidence in submission. I consider the issues in relation to training, if they require further exploration, would be best explored at a later hearing. Having adopted the approach which I have outlined, there are two lines of questioning which I do think would assist the inquiry. These are the issue of the availability of the dog unit raised in questions 34 to 36 and 95 to 96, and the issue of the viability of containment raised in questions 80 and 81. Accordingly, I shall allow the Dean to explore these two lines of questioning. In respect of the applications by Constables Good, Smith and Tomlinson, for the reasons that I have outlined, I do not consider that the inquiry would be assisted by allowing the line of questioning proposed by Mr. Jackson, and I refuse that application. So can we have the witness back, please? Good morning, Ms. Caffrey. You're going to be asked questions by the Dean of the Faculty of Advocates, who represents two of the attending officers and the Scottish Police Federation.
Yes.
Dean of Faculty.
Pleasure, Lord. Morning, Ms. Caffrey.
Morning.
Can I start by looking at the availability of the dog unit, please?
Yes.
And I think your suggestion is it would have been a reasonable option to have waited for the dog unit to have arrived.
It would be a tactical option to consider that.
Mr. Bio was travelling briskly when he was seen.
Mm-hmm.
You agree with that?
Yes.
Yeah. You can't let him move on, given that there are reports that he's in possession of a knife. Do you agree with that?
No, not necessarily. It would all be around the risk and using the national decision-making model, that you don't unnecessarily put the officer lives at risk neither. It's all about the decisions and the tactical response at the time.
We're talking about a situation where the dog unit is some minutes away. In your report, you've adopted 10 to 15 minutes, I think,
Yes.
based on PC Wood's assessment.
Yes.
Am I right in understanding that the viability of waiting turns on the viability of containment?
Sorry, can you explain?
The viability of waiting
Yes.
turns on the viability of containment.
It would still be a decision on the day based on the risk of actual risk or hypothetical risk.
Yeah. Given that there are reports that he is in possession of a knife, he's been attacking cars, he's walking briskly. If you can't contain him, then something else needs to be done, yes?
Yes.
Yeah. Okay. Because otherwise, there is an unacceptable risk to members of the public, yes?
Something that needs to be done could include everything from one extreme of withdrawing and observing up to physical engagement. And again, that would be the decision of the tactical commander at the time.
You gave example in your own testimony of a situation in which you encountered an arterial bleed, as you described
Yes.
it. An arterial bleed is a very serious situation.
Yes.
An arterial bleed left untreated will lead to an exsanguination
Yes.
within minutes, if not seconds.
Yes.
Does that not demonstrate really quite graphically the dangers of waiting?
Yes, because that was an actual risk that we were aware of
Yeah.
for preservation of life, which is always the priority.
Yeah. Well, the fact that exsanguination would happen within minutes or seconds means that when you arrived and there was an arterial bleed, that wound had been inflicted just very shortly before that.
Yes.
If the police had arrived a minute earlier, that wound might have been avoided. Yes?
It may have.
And that's why you can't leave somebody who's reported to be in possession with a knife to roam the streets.
That would be a decision for others than me. All I can say is what the range of tactical options are. And at the end of the day, it's an evidence-based risk assessment using the NDM.
Mr. Woods has now accepted that it would have taken him at least 20 minutes to get from Fetties to Hayfield Road. I think you might have seen that.
Yes.
He's noted as being en route at 7:21 a.m. Yeah, that's a minute after the police first arrived at Hayfield Road, isn't it?
Yes.
You can't really be saying that Mr. Bayo could sensibly have been left uncontained for at least 20 minutes.
It would be the tactical commander's decision, because if for example, the belief was that he had a handgun and then we've got a confirmed firearms incident, there would still be the issues there with sending unarmed officers in or withdrawing them. So again, it's looking at the range of options, tactical options, weighing up the risk and using the national decision-making model to take command.
These officers are dealing with a dynamic, rapidly evolving situation, yes? There's a limited number of officers, all of whom are unarmed.
Yes.
The locus is a busy one. You can see that from the amount of cars that are travelling. He's on a footpath that leads somewhere, presumably,
Yes.
potentially in the vicinity of dog walkers, for example. It's not really viable to contain him, is it, with the number of officers they had?
Not with 2 officers, no.
No, not with 4 officers.
No, be difficult.
Yeah, because the inquiry heard evidence from PC Alan Smith that in order to contain, a lot of support would be required. Do you agree with that?
Yes.
Sergeant Scott Maxwell said in order properly to contain a subject on Hayfield Road, approximately 20 officers would have been needed. Do you agree with that?
No, I've been involved in containments with just 4 or 6 officers. It all depends on the attempt and then the person's response to that. Sometimes the physical presence of 4 officers can psychologically contain the person, and each individual is different, and unless you try, you don't know whether it's going to work or not.
A reasonable officer looking at that location at that time would reasonably have thought it's going to be very difficult to contain.
Yes.
Do you agree
Yes.
with that? Yeah. Thank you. And then once we've got a situation where the officer reasonably believes I can't contain, then it's a fair enough tactical option to approach Mr. Bayo, isn't it?
Yes, it's one of the tactical options, yes.
And in that situation, if you've got gap closing, if you've got failure to respond to lawful commands, and if you are reasonably of the understanding he's in possession of a knife, deployment of CS and PAVA is again a reasonable option open to a reasonable officer.
It's one of the tactical options, yes.
Well, I think that exhausts those that have been permitted.
Ms. Caffrey, thank you very much for coming to give evidence to the inquiry. I shall be adjourning the inquiry in a moment, and you'll then be free to go. Now, Ms. Grimm, I think we adjourn until Tuesday at 10 o'clock, is that correct?
Yes, that's correct. The next witness is scheduled for 10 o'clock on Tuesday.
Very well, the inquiry will adjourn to Tuesday at 10 o'clock.